I'm CNN tech reporter Claire Duffy.
Claire Duffy
is here with us.
I cover artificial intelligence and other new technologies for a living. And even I sometimes get overwhelmed trying to keep up with it all and stay safe in the process. On the podcast, Terms of Service, we can explore how to experiment with these new tools without getting played by them. Listen to CNN's Terms of Service wherever you get your podcasts.
Lately, when I'm looking to redo my wardrobe for a particular season, I'm trying really hard to focus more on quality over quantity, building a wardrobe out of things that are well-made and versatile and easy to reach for every day and always make me feel good. That is why I keep coming back to Quince. The fabrics feel elevated, the fits are thoughtful, the prices are good, and I really do like a bargain. Beautiful everyday pieces using premium materials, things like 100% European linen, things that are actually made of silk, which is hard to find these days, super soft denim. They have styles that start around $50, and the focus on materials carries over to their accessories, including leather handbags that really look a lot more expensive than they actually are. They work with ethical factories, which I really like. They cut out middlemen, so you are paying for quality rather than brand markup. Lately, I have had my eye for spring on a brown blouse. It's silk. It's got puff sleeves and little white polka dots, and I really think it's something that I would feel great in. So you might see me in that sometime soon. You can refresh your wardrobe with Quince. Go to quince.com/KERA for free shipping and 365-day returns. Now also available in Canada. Quince.com/KERA for free shipping and 365-day returns. Quince.com/KERA.
Funding for the Think podcast comes from Wise, an app for people using money around the globe. With the Wise account, you can send, spend, and receive in up to 40 currencies. You can download the Wise app or learn more at wise.com. Terms and conditions apply.
President Trump likes to do things nobody has ever done before, and he certainly made history recently when he became the first sitting president to attend oral arguments before the Supreme Court, watching attorneys who contended that his executive order ending birthright citizenship should be allowed to take effect. The other side argued that order violates the Constitution, although the president left before those lawyers made their case before justices. From KERA in Dallas, this is Think. I'm Chris Boyd. Defenders of birthright citizenship, of mail-in voting, and other targets of Trump's executive orders are also paying close attention to Supreme Court proceedings, hoping justices will rule against the president's single-handed changes. But even if opponents sometimes get the decision they hope for, my guest says the best venue for arguments over which laws we have and how they're applied is not the judicial branch, but the legislative one. Duncan Hosey is a fellow at Stanford Law School. His essay for the New York Times recently was headlined, "The Courts Cannot Save Us from Trump." Duncan, welcome back to Think.
It's great to be back. Thank you, Chris.
I believe you wrote this before President Trump attended Supreme Court proceedings. How surprising was it to you that a sitting president took time out of what has to be a very busy schedule to physically attend a session of the High Court?
I would say it was both predictable and unpredictable. It was predictable in the sense that this is a president who is seeking to intimidate his enemies, and that enemies includes independent courts and judges who rule against him. And so it was predictable that he would push his behavior in unusual ways, and attending oral argument, as you discussed, is an example of that. I would say it was also a little bit unsurprising, just based on what we know about the president overall. He doesn't seem to be someone who is particularly interested in the details of legal procedures. So even though he didn't stay for the whole time, it was interesting. I think birthright citizenship is a great place to start our conversation because it is an example of one of the administration's most lawless actions, something that's flagrantly unconstitutional. And we're in a predicament right now that when you have an administration that does what the Trump administration did with the birthright citizenship executive order, how do you respond to that form of illegality?
How do you respond? Because there are limited punishments, right, for a president who violates the Constitution?
Absolutely. So When we think about constitutional law, which is the area of law that is most germane to understanding presidential behavior, many of the limits are norms. They are not specifically articulated limits that we place on presidential behavior, either through the Constitution or through statutes. They're expectations of public behavior and conduct that have been built over time. And what we see with President Trump in his second administration in particular is a willingness to violate those norms, to do things that are understood to be illegal, even though historically presidents would shy away from that type of conduct. You even see this in his first administration, where there were efforts to do the executive order ending birthright citizenship. And the Trump administration did not pursue that path because there were many people around the president who pushed back. They weren't able to take it over the finish line. And in this second term, the president followed that course of action. The way to understand the difference is that there's a collapse of the norms in presidential behavior, including in the individuals who surround the president who are committed to some of those norms.
You remind us in the article that at the end of the 19th century, the legal scholar and future Supreme Court Justice Oliver Wendell Holmes wrote about this theoretical idea of the bad man. What sort of figure was he talking about?
The Bad Man comes from a seminal essay and speech given by Oliver Wendell Holmes in 1897. At the time, he was a justice on Massachusetts' highest court and a legal scholar at Harvard Law School. In the essay, Holmes comes up with the idea of a bad man, which is a way to understand how law operates in practice. The bad man in this Holmes paradigm is an individual who is not concerned with how his actions are ethical or moral. The bad man is only concerned about the prospect of receiving consequence for doing bad things. So the bad man isn't reflecting on whether stealing violates some ethical code. He's thinking about, well, am I going to go to jail if I steal? Am I going to face some type of financial punishment if I steal? And so it's a way to understand how some people are oriented to the law and aren't governed by just high moral principles. To understand Trump, you have to understand the bad man.
Yeah, talk a little bit about why the bad man may be troublesome for society, but isn't a significant obstacle for contract law or for criminal law to deal with.
Contract law and criminal law have the ability to impose some forms of consequences on individuals who violate norms or statutes. And you see this in Trump's individual behavior, that he, as a businessman, would enter into various forms of real estate contracts and violate them. Famously, he would encourage people who he owed money to, kind of like contractors, people who worked on his real estate projects, to sue him to get their violations. And ultimately, he bore some consequence for that type of behavior. If you look at his ability to get credit, people understandably didn't want to work with him in the same degree as they had previously because they knew this was someone who wasn't reliable, who wasn't following their obligations. And so contract law and criminal law aren't perfect in dealing with the bad man. It's always a problem in the society in which you have some individuals who decide they're not going to participate by the same rules that everyone else is, but they're predicated on the ability of imposing some type of consequence that people follow. And a bad man in contract law or criminal law may still engage in bad actions, but if the bad man is doing that, it's a result of either the contract penalty not being strong enough or the criminal sanction not being strong enough. And the bad man is calculating that, the expected value of engaging in the behavior I don't like exceeds the likelihood of punishment. Constitutional law is different because we don't have the same type of risk-reward calculus. We expect people who occupy forms of public office, especially the Oval Office, because in our constitutional system, that's such an important role, but also judges and members of Congress and other people who take a constitutional oath of office, to recognize that they're serving the public good, they're serving a higher purpose, that their ability to effectuate their job isn't just out of either self-interest or parochial political interest. And so, whereas in contract law, Trump was able to get away with some things, but also face consequences, when you're dealing with constitutional law, we don't have the same type of tools to tame the bad man. And accordingly, if a bad man rises to the Oval Office, the harms are going to be greater and spread to many more people.
So this is why there's been so much talk about a constitutional crisis or potential constitutional crisis with President Trump, right? Like, if everybody in a position of authority tells him something violates the Constitution and he rolls ahead and does it, this question is like, what now?
Absolutely. I think that's the nub of the constitutional crisis that legal scholars, including me, see ourselves in at this moment. That we have a president who is unbounded, and unbounded not just in terms of their action, but the motivations of the action. That there's this lack of reflection on what it means to be constitutional or not in terms of how you occupy office. And again, that's because we have norms associated with this type of conduct that have been violated. And it's easier to break norms than build norms. So a big project over the next generation is rebuilding certain standards around government behavior. But right now, at least in the short term, we have a really serious dilemma about how to deal with this individual in the White House.
I want to talk about the premise implied by the headline. And I realize you may not have written the headline, but I want to talk about this anyway. What tells you that we, by which I think you mean the American public, need saving from the president?
When I look at the Trump administration, I see an administration that not only is engaging in policy I disagree with, but is predicated on an understanding of what the executive can do that far violates the structure of American government. That's why I think increasingly you see Republicans, conservatives, individuals who agree with the president on particular policy agendas speaking out against so many of this administration's actions. And in part, we have an administration that is not just motivated by ideological goals, although that's certain to it, but a type of animus towards political opponents and a willingness to target the systems of democracy and speech. In the New York Times op-ed, I began by talking about the Trump administration's executive order targeting law firms that are associated with individuals the president has either opposed politically or just doesn't like. And the administration, in coming up with these executive orders targeting these law firms, gave no reason why these law firms were a national security threat. There is no reason why they're a national security threat or problem, but they were being targeted by the full force of the federal government for the sole reason that the president didn't like individuals who worked there or the general overall liberal bent of the law firm. And executive order case is, I think, important because it shows we're dealing with an administration that isn't just doing conservative policy, which people can agree or disagree with, but is violating fundamental democratic principles that allow the ability of Americans to speak out on issues that are important to them. And law firms are perhaps a conspicuous example, but there are many, many examples of the administration going after the speech of its opponents, of trying to weaken electoral systems of democracy, of going after what it sees as competing power centers. And that is a flagrant violation of our constitutional structure that has nothing to do with the overall conservative leanings of the Trump administration.
Some law firms have just sort of rolled over and tried to appease the White House by complying with the president's executive orders. What happened, though, when a few of those legal practices decided to resist and go to court?
There were 4 courageous firms that sued, and they almost instantaneously from courts received injunctions barring enforcement of the executive order against them. What that meant is that they convinced district court judges to say the Trump administration cannot enforce these executive orders against them. Ultimately, though, and I argue this in the piece, that it is a mistake to view those district court injunctions as remedying the ultimate problem. Because the ultimate problem is that we have a White House committed to censoring its political opponents. And if the goal is censoring political opponents, the Trump administration doesn't actually need to win in court to achieve that goal. It just needs to create the overall conditions in which individuals self-censor, think about speaking out, think about taking on clients that are opposed to the Trump administration. And even among those 4 law firms that you mentioned that successfully obtained legal relief against the Trump administration, you've seen a disinclination to taking on some of the pro bono cases that they had taken on in preceding administration, in the past Trump administration, because they understand that doing so could potentially subject them to additional penalties from the administration. So the point of the piece is not to criticize those law firms for suing. I think it was essential that they sued and it was noble that they sued, but it was on all of us to not think that the act of suing and getting a court order is sufficient to dealing with the problem that we're dealing with in terms of this constitutional crisis.
So you're saying there's quantifiable evidence that law firms, before they decide whether or not to take a case that is particularly political, they're they're thinking about what the president might have to say about it in a way that they wouldn't have under other administrations.
Absolutely. And we have quantifiable data on this in the first Trump administration. Big law firms, which refer to a set of multinational firms with corporate clients, think of the representation of Fortune 500 companies. They normally use either in-house, in addition with some big law firms. But big law firms in the first Trump administration were the backbone of the legal infrastructure resisting the administration. And in almost all of the important cases challenging executive orders against the Trump administration in the first administration, the big law firm was involved. And in some cases, like Paul Weiss in particular, big law firms were leading many of the most important cases and really were leading the cases. It's not just that they were assisting in the cases, that they were the ones spearheading it. In the second Trump administration, we've seen a complete decimation of that big law participation in orders challenging the Trump administration. And beyond that, a reduction in services provided for working on particularly immigration, but other causes that don't directly challenge the president policy itself, but are associated with things that the president doesn't like. So even the peripheral area, you're seeing a chilling effect and a change in behavior.
Duncan, in terms of that headline again, the exact wording there is that the courts cannot save us. Would will not have worked too? Will not implies cannot. Cannot doesn't necessarily imply will not. Is there any appetite among a majority of justices to keep the president within traditional constitutional boundaries? Is it simply a fact of, they don't have the power to do this?
It's a fascinating question. I think the headline, "The courts will not save us for Trump," would have led to a slightly different argument. The argument would be that courts, differently composed, perhaps would have the tools and the willingness and the ability to curb the president. And I think some on the American left would make that argument that the correct phrasing would be "will not save us from Trump." And they might even point to the current Supreme Court, where we began our conversation. Of course, Trump has reshaped the current Supreme Court. He appointed 3 of its justices, in Justice Gorsuch, Kavanaugh, and Barrett. You could imagine a different scenario in which you had a liberal Supreme Court, a Supreme Court with, let's say, Hillary Clinton won in 2016 and filled some of the crucial vacancies over that time period. Maybe that type of court would be more willingness to intervene against the Trump administration. Ultimately, I don't think that the core problem is the composition of the courts, that I think even if you had a judiciary overall that ideologically was more hostile to the president, that courts themselves as institutions aren't sufficient for the scope of the problem. We're dealing with administration in this constitutional crisis that has hostility to the rule of law. And in that type of democratic collapse, I don't think it's reasonable to expect that the institutions that are committed to the rule of law will be able to overcome that larger problem. I think you have to shift domains. But I understand your question that the framing about "will not save us for Trump" does speak to an important dimension of this, that the problem isn't just courts, qua courts, or courts in their nature as courts, but of the specific people we have, particularly at the Supreme Court, but in the appellate judiciary overall.
To go back just briefly to President Trump's recent appearance at the Supreme Court, do you know whether, this was not the first executive order by President Trump to make its way to the Supreme Court for review. Is there something special about this particular one that caused him to show up, or did he think maybe I didn't get my way for some of these other rulings? Maybe if I go, I will, be able to have some influence.
This is a particularly animating issue for him. Overall, of course, immigration is perhaps his top political issue, one that fueled his political rise. And in that political rise, he's often talked about what he calls dismissively and derogatorily as anchor babies. This executive order goes against his conception of a very serious problem. So I understand his presence there, both as a way to intimidate the justices generally, but also to convey to them the importance to him of this particular topic. And that's not always the case with the president, but this is an issue I do think he cares deeply about, and that's why he attended there. I think it's important to note that the court is almost certainly going to rule against the president in this case. So his ultimate presence in the courtroom, I don't think, will dissuade the justices, including probably the justices he appointed, which is perhaps the most direct mechanism he thought his presence would have in the courtroom. But related to the thesis of the article, Trump can win by not necessarily even triumphing in court, that he's changed the goalposts, the idea that birthright citizens under the 14th Amendment wouldn't have citizenship was such a kooky, off-the-wall idea up until relatively recently. The act of litigation has legitimized this really strange concept that's foreign to America's constitutional culture. And the case reached the Supreme Court only after a case previously in last year. In that case, I won't go into the details of it too much, but it was a group of immigration rights organizations challenging the Trump administration over this executive order. And the Supreme Court curbed the ability of district courts to issue nationwide injunctions. And that had the short-term effect of insulating some of the Trump administration's policies from legal review. So even in the saga of this particular case, the Trump administration has actually had some legal wins.
I mean, the president of the United States, any president, is a very powerful individual. The executive branch has grown ever more powerful in recent years. We'll talk about that in a minute. I would think, though, strategically, Duncan, that there's a risk in the president really, applying very visible pressure to the justices of the court by his presence during those arguments. It would seem as if there might be a desire on the part of the justices to simply assert themselves by ruling against him. Maybe that was no consideration whatsoever, but what do you think about that?
I think you're right from the narrow question of, in the resolution of this particular case, is my presence going to help or hurt? I think it almost certainly hurts. The justices are not going to like the fact that in such a blatant way, he's putting pressure on them. In the first Trump administration, there was this revealing moment in which Trump responded to a court order against him by complaining about a so-called Obama judge. And Chief Justice Roberts, who has in his judicial career really focused on defending the institutional legitimacy of the Supreme Court as it's been under strain and as its legitimacy has been challenged, responded to Trump by saying there's no such thing as an Obama judge or a Trump judge or a Clinton judge. We have a collection of really committed, serious public servants who are trying to do the best that they can. And so you see just in past practice, when Trump launches this really direct fusillade against the court, its justices begin to chafe. I also think in terms of your question of Trump's presence at the oral argument, it's important to note that he just suffered a really significant loss at the court in the learning resources case. You listeners will know that case is the tariffs case, where the court rejected the president's capacious authority there. And Trump responded to that by launching really vicious personal attacks on the Republican appointees who disagreed with him in that case, suggesting that the families of Justice Gorsuch and Justice Barrett should be embarrassed. And that's an example. I don't think that is going to endear him to the justices overall. So I do think a more narrow way of looking at the court's relationship to Trump there. So far, the court has been relatively favorable to the Trump administration overall, even with these losses. That's primarily coming through two things: the court's orders on the shadow docket and the immunity decision. And I'm happy to elaborate on both of them. Although I can talk about either of those, but I think the broader point would be that this is a court that actually has given Trump far more of what he wants than he's entitled to. So he should be pleased with what the court has done.
To be fair to the current president, we should note that an ever more powerful executive branch is bigger than one administration, right? It did not start with Donald Trump.
Absolutely. This is a long-term accretion of presidential authority, and it goes under Democratic and Republican administrations. You can talk about it through the lens of the imperial presidency, which traces back way back to the middle of the 20th century. I do think there are key junctures in the growth of executive power. The George W. Bush administration is a particularly crucial one. During that administration, you see a synthesis of the unitary executive theory, which floated around in the Reagan administration, but had largely not received the type of institutional codification. Unitary executive theory is this very aggressive, assertive understanding of what the president can do under Article 2. And Trump is leaning into that theory. And the Supreme Court has endorsed that theory, at least parts of that theory, in the immunity decision, Trump versus United States, and in actually some other decisions too. So I would say you're seeing in the Trump administration this growth of a really strong executive over time. But even against unitary executive theory, we're seeing the Trump administration act in ways that are unprecedented, not entirely supported by that theory, and to me and other critics of the administration, very dangerous.
I mean, recent presidents, including Trump, would argue they issue executive orders to enact policies because Congress can't get things done through legislation. Important things. Is that accurate or fair?
I'll begin by responding to the argument in context of Trump, and then I'll talk about Congress overall. In context of the Trump administration, we have seen a lack of desire to even go to Congress for legislation. The Republicans have a majority in both houses of Congress right now. The president could have began the first 100 days or first year of his presidency by going through with a comprehensive legislative agenda and seeking its enactment. Instead, he's preferred to govern through executive orders and has written out Congress from that process overall. So it's kind of curious, if you were thinking about how to make your policies last over the long run. I think you would want to go to Congress to get another branch of government's approval of what you're doing, to get their imprimatur on it. But for a variety of reasons, the Trump administration has preferred to govern by executive order. I think the larger point is right that Congress is weakened right now. It's debilitated. It's a polarized institution. And so in periods of divided government, Congress will become sclerotic and not act. And then in periods of unified partisan control, including when Democrats control all branches of government, you see just a willingness of Congress to defer to the executive. I think one of my academic projects, and this goes back to my interview previously on the show, is revitalizing Congress as a separate source of power and authority, and to have members of Congress think of their responsibility not just to party loyalty, but to their constituents, to various causes. And that may be challenging the president of their own party. It may be supporting him or her when they're aligned. But there is a larger story here about the decline of Congress.
Was the power to issue executive orders created for the express purpose of letting presidents leapfrog over legislative stalemates?
The power to issue executive orders absolutely was not created for that purpose. We have seen, certainly under the Trump administration, but again, there's a larger context here in the Obama administration, in the Clinton administration, in the Reagan administration, a willingness to use executive orders in unconventional ways to seek policy goals. During President Obama's administration, there was this famous moment that Republicans retook control of Congress and weakened his political position in terms of enacting a legislative agenda through Congress. And President Obama responds by famously invoking, well, I still have my phone and I still have my pen. And what he meant by that was that he still had the ability to influence people from his phone, calling, setting the agenda, narrative building, but also pen, that he could still sign executive orders. So I think you're right to underline that the Trump administration is not the first administration to view executive orders as a way of circumventing Congress. Here, though, it's interesting that the Trump administration could probably get legislative support from House Republicans for almost all of its policies. We really have not seen across the board a willingness of House Republicans to challenge the president. But I think why the Trump administration is using executive orders in this context, it's faster. There's a degree of almost performance the president likes about signing things quickly. Legislation, even among the same party, can require negotiation and horse trading. Just that type of normal act of legislating is itself somewhat annoying for someone who wants fast action. And this goes back to the bad man theory. But when you have someone who has authoritarian instincts, there's this appeal of a strong man who just comes in and gets everything done immediately. And that's why I personally view the Trump administration as relying on so many executive orders.
Duncan, if lawmakers in Congress, lawmakers of either party, agree with the substance of the policy that the president wants and issues an executive order to make happen, but they object to the method, what is their ethical obligation?
I think the ethical obligation begins by speaking out. When you talk to members of Congress, you'll often hear in private a willingness to criticize this president, and then in public, complete reticence or even enthusiastic support from him. And I think from an ethical perspective, a baseline, you should be the same person you are behind closed doors that you are in front of the cameras. So I wish lawmakers who objected to birthright citizenship, for example, had said so clearly. Instead, you saw depolarization on this, where most House Republicans either signed an amicus brief supporting the administration or didn't say anything, and you saw universal disagreement with what the administration had done from the Democratic colleagues. I think, too, there is a longer-term project of members of Congress trying to reassert legislative authority over acts of policymaking. And part of that would be passing bills on questions of national concern. And once you really get back to that act of legislating, you obviate the need for some of these executive orders and also make it more untenable for a president to claim that the only way to get things done is through this unitary action coming from the Oval Office.
To go back to the premise of this article, if the courts cannot save this country from executive overreach, does that suggest a flaw in the Constitution itself, or is it, in fact, the result of the legislative and judicial branches failing to exercise the full extent of their powers to check that overreach?
I wouldn't say that it's a flaw of the Constitution, but actually the strength of the Constitution. When I read the Constitution, I see a document that rests the ultimate authority and power with the people to vote, the people to organize, the people to speak, the people to rally, not with judges. There are other constitutional systems in a comparative law context where, by design, the Constitution views judges and the judiciary as the proper arena for solving all these questions. And I don't think America has a constitution of that nature. And I think that's salutary, that we want a political culture in which ordinary people are able to make a difference. In the op-ed that we're discussing today, one of the things I write is that courts, while important, are not going to be ultimately the institution that saves us, but you can do so through direct action, and voting is perhaps the most direct way. But even extra institutional forms of action, like what we saw in Minneapolis, are ways people can participate in changing policies that they dislike and slowing down policies that are harmful from an administration with which they disagree. And I think, again, that the ultimate brilliance of the Constitution is, and it's again not a perfect document, but its insight is that the authority in a constitutional democracy can't rest with a few judges. It has to rest with the people.
Duncan, you mentioned a moment ago that ultimately the Constitution is designed to give power to the American people. With members of Congress, it seems like the ultimate flex for constituents is voting them out of office every 2 years or every 6 years, whatever the case may be. And of course, this is a concern for first-term presidents. Are the stakes, though, just different for a lame duck or second-term president?
Historically, a second-term president would be really focused on their legacy, how they want to be remembered from the perspective of history. I think that is a concern for Trump. You saw recently they released plans for his library in Miami, and it was this towering, gaudy spectacle. So it's clear that he is thinking about how history remembers him. But I ultimately think that this president may be different in some ways about how he's viewing his relationship to history, that the type of lawlessness we see emanating from the White House would, to past presidents, just be beyond the pale, in part because they don't want history to remember them in the way we remember Nixon or some of the most sordid leaders in American political history. And I think that concern is either not weighing on Trump, or it weighs on them differently, or they think that they will triumph in the court of history. But you're seeing a set of actions from a lame duck president that are out of the ordinary. I think, too, that we're approaching lame duck status, but we're really not there yet. If Democrats manage to retake either or one of the houses of Congress in the upcoming elections, then it will be magnified. And I think the presidency will shift too, because Democrats will have the ability to engage in investigations and oversight in a capacity that they are not able to do so now. And that will slow down what the administration's doing in a material way.
How did the Supreme Court's ruling about presidential immunity in Trump v. United States, which was handed down in 2024, change the stakes for any president who argues some action they have taken was part of their official duties as chief executive.
The way I would think about Trump versus the United States is on two levels. One is practical and one is atmospheric. In terms of practical, a president, including President Trump, doesn't have to worry that some forms of official action are going to lead to criminal sanction. So, for example, when you see President Trump target these boats off the coast of Latin America in the Caribbean that they allege are drug smugglers, even though there is very limited evidence in most of these cases that they are drug smugglers, a past president may have to worry about murder or types of really serious charges being brought for that type of behavior. A president historically has not been understood to possess the authority to just go out and shoot down people without following acts of war or going through other legal processes and procedures. I think Trump, the United States, on a practical level, led to the administration in that case, and particularly maybe some of the lawyers sympathetic to Trump around him, thinking, okay, there is a less likelihood of accountability from that decision. I will say that I think the most impactful consequence of Trump versus the United States doesn't actually come in that individual policy determination analysis that I alluded to, but is at the atmospheric level. So it's a signal from the Supreme Court to Trump that we have a deferential view of executive authority, and we're going to let you do what you want to do, subject to most conditions. And that doesn't mean the Supreme Court will never intervene against him. We've already seen intervention in the Merits case of the tariffs against him. But across the board, the Supreme Court in Trump for the United States and other decisions has communicated a message that we're not actually viewing this as a constitutional crisis in the way that other people are. We're going to treat President Trump with what legal scholars would call the presumption of regularity, that we're going to assume the government is acting in good faith, that they have reasons for what they're doing, and that courts need to look at those reasons with really serious concern. And Trump versus the United States is just one example of that larger atmospheric tone that I think, particularly in the first year of the second administration, led the administration to do so many things that were unconventional and unprecedented.
Am I correct about this, that under the Trump v. United States ruling, courts are not even allowed to investigate what any president's true motivations might have been for taking some official action that would otherwise be against the law for anyone else?
I think that's a fair assessment of the gist of the decision. And it relates to a broader trend of the Roberts Court, which is the period of Supreme Court history in which we live, of not questioning Republican presidents on their motivations. For example, in the Trump versus Hawaii case, which deals with executive orders in the first Trump administration to do a Muslim ban, or that was what they were really doing. The Trump administration had pretextual justifications for why they were targeting these countries. The Supreme Court says essentially what you see in your comment there, that we're not going to doubt the motives of what the Trump administration is doing, even though we had this litany of statements of Trump making anti-Muslim statements, of running on an explicit promise of a complete and total shutdown of Muslims entering the country. The court is just saying we're not actually going to get into some of those motivations there. It's not our proper role. It's not that the Supreme Court is never questioning the motives the Trump administration is doing, but I do think it's a fair statement to say across the board they don't think courts should be engaged in that type of inquiry.
Forgive me for asking a question that might cause you to fail a first-year law student, but
no, it's good.
What are the dangers of a president who appears to feel unbound by constitutional law or precedent or even norms?
It's a phenomenal question, and I think it's a question that we're living through right now. So if you were on a first-year law exam, I don't know how I would answer because we're in this experiment together. But I would say that our constitutional structure gives the president an enormous amount of authority, that the specific responsibilities and duties and constraints and obligations of the president aren't demarcated with specificity, at least compared to other constitutional systems. And because of that, when we think of presidential behavior, we need people who are transcending just their personal interest and thinking about their role in terms of the interests of the nation. And I would say that there are some exceptions. Nixon most notably comes to mind, but even presidents I disagreed with shared that promise. So I wouldn't have voted for Ronald Reagan, but I do think at the end of the day, Ronald Reagan was pursuing what he thought was the best vision of America, and he was following some bounds about how that action would work. And it doesn't mean that everything he did was legal. Iran-Contra comes to mind, but across the board, the administration was trying to abide by the law and was trying to work within the confines of our constitutional system. Now, I think we're dealing with a president who is more extra legal in his orientation, who isn't engaged in the same type of project. And the result is that you can have a collapse of constitutional democracy. We're not there yet. There's still ways people can resist. There's still ways people can vote. There's still ways people can speak out. But because the administration has not bought into this constitutional project, they're willing to go into areas that have been off bounds historically, especially speech, especially the ability of people to organize. And that is just really precarious because it risks creating an inability of people to remove either that president or that president's political party from office if you weaken the structures of representation that allow you to remove that type of person.
Are you able to articulate a clear distinction between any presidential administration that is trying to abide by the law, as you said you thought the Reagan administration was, versus searching for legally plausible justification for interpreting the law in a particular way?
Presidents come into office with an agenda, and we want them to be able to effectuate the agenda because ultimately that's the people's agenda, or the people's agenda as modified through our electoral institutions, which are not always going to give direct access to the people. But when a president comes in with his or her agenda, you want them to be able to pursue it, and that will require sometimes coming up with new legal arguments. What I see in the case of many of these Trump administration policies, the executive orders we talked about against the law firms are a good example, is that the administration is using the form of legal argument. They're citing cases, they're filing briefs, but they really are not making legal arguments, that they're not seriously grounded in the norms and conventions and forms of legal argument as we understand it, that it's kind of like a Potemkin legal argument, that it has the facade of legalism, but there's really nothing there. And this goes to another point in the op-ed, but when you are dealing with a bad man, one of the things they do is try to use the legal process for ways that are not about actually getting a result, but to create costs. Litigation is expensive. It can be nasty. It can be tiresome. Some people will try to settle instead of engaging in litigation.
Duncan, what can Congress do to wrestle back some of the power they have ceded to various presidents in the executive branch in recent years?
I think Congress ultimately will not change until members of Congress view their responsibility as not to a party, but to the people or to their constituents. So you need an attitudinal change before some type of structural one. And I think to get the type of Congress we need, you would have to have many forms of democratic intervention to the structure of elections. So you would want some form of campaign finance reform that reduces the influence of big money in politics. You would want to restore parts of the Voting Rights Act, which have been eviscerated by the current Supreme Court. And you would want to do other things that make the systems of representation stronger. Ultimately, though, those things are unlikely to happen. And I think people shouldn't despair if Congress is not going to rise to the challenge. There's still so much that ordinary citizens can do in our daily lives. In Minneapolis, there were 2 lawsuits against the Trump administration for a particularly brutal form of immigration sweeps. And ultimately, both lawsuits did not result in injunctions stopping the Trump administration. You saw members of Congress during that time period introduce legislation to try to stop some of the abuses in Minneapolis. Those bills went nowhere. But people in Minneapolis, just ordinary people, were able to step up and reduce some of the harms of the administration. People tracked ICE in real time to individuals at the cost of their own lives. People deliver groceries to immigrant families who are scared to leave their homes. And though it actually, at the end of the day, didn't get rid of ICE in the city, but it reduced the number of ICE agents in Minneapolis. The Trump administration ultimately removed some of the ICE officers from the city, in part because it was becoming logistically difficult to maintain the operation there. And, in terms of individual people's lives, when you're delivering groceries to people or helping with childcare or stepping up in other ways as a community, you're able to make real differences in people's lives, even if these formal institutions of Congress or the courts are not meeting the moment and meeting their responsibilities. So it's a long way to say that I'm not expecting Congress to save itself anytime soon, but we still have lots of power as citizens, and we should never forget that.
What do you think the midterm elections will tell us about the extent to which Americans want their lawmakers to do something different?
The midterms are absolutely crucial, and everyone needs to think about the responsibility they have to vote. This is the first national ability of the people to weigh in a formal, codified way on the direction the Trump administration has taken. It appears the Trump administration's approval is exceedingly low right now, and it's been plummeting quickly, in part because of the war we're engaged in right now with Iran. If there is a way to turn that public sentiment into a change in Congress, it will actually lead to a concrete check on the administration. I just talked about some of these informal mechanisms about people stepping up in their community. But if the midterms go against the Trump administration, you think you will see greater investigations, greater accountability, greater just sunlight and transparency into what the administration's doing right now. So much of what the Trump administration is doing is opaque because for a variety of reasons, we rely on a vigorous Congress to be reviewing what the executive is doing, and we're not right now being able to have that. I also think that if the midterms go against the Trump administration, you'll see a change, maybe not drastically, but a change in some of its behavior, because it will know that there's this competing power source, and that will influence decision making. The final note I would say is that judges are confirmed through the Senate. There's a possibility that we'll have imminent Supreme Court vacancies. Justices Alito and Thomas are both relatively old, and there's pressure on the right for either of them to retire. But if they don't retire between now and the midterms and Democrats retake the Senate, there is a direct way that actually the court's composition will be on the line. And so people should think not just voting for, okay, the president, do I like him or not like him, but what direction do I want the Supreme Court to head in? And am I satisfied with the direction the current court is on?
Duncan Hosey is a fellow at Stanford Law School. His essay from the New York Times was headlined, "The Courts Cannot Save Us from Trump." Duncan, thanks very much for the conversation.
It's always great to be here. Thank you, Chris.
Think is distributed by PRX, the Public Radio Exchange. Find us on Facebook, Instagram, anywhere you get podcasts, or at think.kera.org. Again, I'm Chris Boyd. Thanks for listening. Have a great day.
From PRX.
This show is supported by Odoo. When you buy business software from lots of vendors, the costs add up and it gets complicated and confusing. Odoo solves this. It's a single company that sells a suite of enterprise apps that handles everything from accounting to inventory to sales. Odoo is all connected on a single platform in a simple and affordable way. You can save money without missing out on the features you need. Check out Odoo at odoo.com. That's odoo.com.